Hi, everyone, and welcome to this week's episode of Law Chats with John and Amy. I'm John Yulian.
I'm Amy Poliapico. This week's question is, what is a contempt in a divorce?
Amy, maybe I could start out with giving a couple examples of contempts. I think a very common one people are aware of is non-payment of child support or alimony. Those are very common contempts that are brought against the individual who's not paying the child support or alimony. Did you want to jump in?
Yeah, so
It looks like you want to jump in, so feel free.
So generally a contempt is when there's a clear and unambiguous court order, say perhaps this person needs to pay $400 a week in child support to their ex-wife. And then the second part is that they have the ability to pay it. So that means, Joe Schmo was supposed to be paying his wife $400 a week. He's working, he has the money, but for some reason he's spending it on something else, or he's just fallen behind. That would be a case that could be contempt. But not everyone actually has the ability to pay. And so that could be a reason, a justifiable reason, and when you wouldn't be in contempt. You want to maybe give a good example of that?
Sure. And if we take the same Joe Schmo, and Joe had lost his job, and was either now his income was reduced because he's getting unemployment, or maybe he doesn't have a source of income, that could be a defense to a allegation of contempt. He hasn't had the ability to comply. But what happens sometimes is someone, instead of paying part of the weekly obligation, will pay nothing. And when someone pays nothing, it is an awful tough argument to say you haven't had the ability to comply at some level, meaning, sending some portion of the weekly amount, and being able to avoid the contempt. So just a word of caution for people who do literally pay nothing. You will have a very difficult time convincing a judge that you're really doing the best you can and shouldn't be held in contempt.
And then part of that is we said that the order needs to be clear and unambiguous, and that could be a court order, it could be part of your divorce separation agreement. And so sometimes we have people come in and say, hey, it says we're supposed to figure out who's paying what for college now that my kid's a senior in high school, and we haven't been able to figure it out. That's not a contempt because the court order isn't clear. It doesn't say, person A has to pay 50%. It says you guys are going to figure it out. So that might be an issue where you're trying to file a complaint for modification, which is something we can talk about in a later episode. But that would not be a contempt issue.
That's correct, Amy, and that's a good example of something where, and this goes on plenty of times, someone brings someone in on a contempt, but the parties can't even agree on what the language was requiring. Well, it's pretty tough to hold someone in contempt if it's not even clear what they were obligated to do. In fact, if it's not clear what the person was supposed to do, they won't be found in contempt. The one other thing I think is important, Amy, is what the potential consequences are for a contempt, which can include a certain time period for the person to correct, if it's non-payment, the arrears, the court ordering that someone have to come up with a certain amount immediately. Mm-hmm. And then, the court issues some type of repayment plan. But the most extreme penalty in a contempt is the person can be incarcerated. Now, that only happens, as I say, in extreme situations where I think the court is seeing someone repeatedly violate the court order and or ignore the court order, because I think any judge gets frustrated by that. But you can sense the cases when you hear them, and I've been involved with them, where you have someone repeatedly defying the court order, because it can be the first time you bring someone in on a contempt and they're behind, and the judge issues some type of order of how they need to rectify the situation or what's going to happen going forward. And sure enough, a couple months later, a few months later, whatever, you're back in court for a status update, and the person still maybe playing the same games, not being honest, not disclosing their true financial situation. Once again, ignoring defying the court orders. When that's happening repeatedly, someone's really pushing their luck, and sooner or later, the judge is going to be saying, you're going to go to time incarcerated, and you can purge yourself. That's the expression they use. You can avoid the incarceration by coming up with X amount of dollars immediately. And usually the person makes a quick phone call and suddenly that money appears. But
that's what I was going to say. I know that a couple times, it wasn't our case, but on a different case, you'd come back and magically the judge will finish the case, have them sit in the back row with a court officer and tell them, you've got till 4 o'clock till we drive you back over to jail. And they are texting on their phone, and magically some friend or family members show up with the cash that they need.
Sure. I remember one that always stood out to me, Amy, because I thought it was a good line by the judge. But the judge was frustrated with not our client, but the ex-spouse. And it was a contempt, and we'd been in a couple times. And I think the judge, rightfully so, was frustrated by the other party. And the judge said, if we're back here next time, and the judge was giving us another hearing date, and you have not complied with the order, make sure you bring your toothbrush because you'll be needing it, right? I mean, and I think the judge was making it very clear to the other side, if you don't follow what I'm doing, you can plan on spending some time incarcerated. So it's not a fun thing,
No.
Obviously, to not comply with court orders and be taking your chances on a contempt.
Also, I mean, if you're the person pursuing a contempt, it doesn't necessarily help you if the other party's in jail and not working. That's not going to magically get them to be able to come up with the money. But as the judges have alluded to, knowing that you're going to jail that night is a nice motivator to get you to call everyone to come down to the courthouse. So it is a possibility. One thing that we just didn't mention, and I wanted to bring up as another penalty, is attorney's fees.
And that's a great point, Amy. So when you go in on a contempt, you're basically going in claiming that the only reason you have this court proceeding is because the other side is ignoring or not following a court order. So when someone brings a contempt, it's almost a given they're going to be requesting their legal fees. And the argument is, I wouldn't have to have incurred these legal fees if the other side did what they were supposed to. If the court finds a contempt, the court can order that the person in contempt is also going to have to pay for the legal fee. So it is another reason to do your best to comply with the existing court orders and not run the risk of having to be brought in on a contempt. But it is the one mechanism someone can enforce a court order when the other side is just not cooperating, just ignoring their ex's calls and so forth, right? And just disobeying the obligations 100%.
So the last thing we just want to talk about is the process for how a contempt works. You file a contempt like you file a complaint for divorce. It's a complaint for contempt. There's a standard form that you submit to the court, and like filing a complaint for divorce, the court has to issue a summons, which doesn't get done right away. You hopefully get it in a week or two. The nice thing is, unlike in a complaint for divorce, when they issue the summons, they automatically give you a court date. But I will say we got a summons on a complaint today, and our court date is the middle of April. So you're not getting in right away. And then you have a court hearing where the judge hopefully can issue an order, or maybe you reach a stipulation, hey, I'm going to get caught up in this amount of time, or it's not always that the person is behind on something. It could be that they were supposed to provide documents or whatever it was that they're not doing that they were supposed to do. Hopefully either you're entering into an agreement that they're going to do it by a certain date, or the judge is going to order them to do it by a certain date. Typically you'd have a second hearing if the things can't get resolved. And then after that, if you still can't get resolved, you can have a trial on a complaint for contempt like you could a trial in a divorce. Oftentimes in a divorce, there are their own separate complaints for contempt because people aren't complying with stipulations or temporary orders. And if you did have a trial in the divorce, they would try both issues at the same time.
Okay, Amy, I think that seems like a good place to wrap up for today.
Thank you for joining Law Chat with John and Amy. We look forward to chatting with you again next time.
If you have a question or comment, feel free to email us at info@yulianlaw.com. Remember that Law Chats with John and Amy is intended as a general reference and considered general advertising, and listeners should check for changes to any applicable laws and consult with an attorney on any legal issue. The information provided does not constitute legal advice, and any thoughts or commentary by the podcasting lawyers is provided as a service to the community and does not constitute solicitation of legal advice. The lawyers in the law firm of Julian & Associates PC make no warranties and disclaim all liabilities for damages resulting from its use. Nothing provided in the podcast should be considered a substitute for advice from counsel. No attorney-client relationship is formed by listening or participating in this podcast, and in the event that the podcast receives emails about the subject matter, no attorney-client relationship is created via the email communication.